100 questions about a will challenge.
First of all the material on your binder is on this flash drive. Any resemblance to my partner Greg Sidlowski is not coincidental. I want to make a special thank you to Print 3 Sheridan of the Path at the lower level concourse near 123 Queen Street. We had a last-minute flood of people registering for this event, so at the last minute they put together an additional 40 binders. And they donated the printing cost today. Before I pass the baton on to Judge Jordy for us to start this event, I want to answer a question that a number of you have been asking me. Why does B'nai B'rith do an estates and trust seminar for lawyers and accountants? I suggest that the answer is pretty much the same. Why many of the presenters in this room specialize in estates and trust litigation. With the permission of the rabbis in the room, I'd like to share a short story, a vignette from the Talmud, which might explain why we do what we do. Thousands of years ago, before the printing press, Jews used to pray, but they had no prayer books. So often the wisest and most sage of us would lead the prayers because he knew the prayers off by heart. But what happens when the elder sage no longer remembers his learning, no longer remembers his prayers? When age or illness makes him less capable than we once were. Says the Talmud, be careful regarding how you treat an elderly individual who has forgotten his learning. Where do we know this from? Asked the Talmud. The answer is, when Moses came down from Mount Sinai and he saw the Jews sin with the golden calf, he had the 10 Commandments in his hand, and he was so angry, he broke them. And he had to write a new set of tablets. He put the new set of tablets in the Ark of the Covenant, and he also put the broken tablets there. What is the Talmud telling us? I think it's obvious that even when a person seems broken, he no longer or she no longer has the memory she once had. He or she can no longer articulate what they want to happen at the end of their life. They still have sanctity. Their wishes still have meaning. When they leave this world, for those of us who are involved in this industry, when the aged or the infirm or the unwell leave this world, we do our best to ensure their wishes are still honored. When they are no longer capable to care for themselves or to make their end-of-life wishes known, we advocate on their behalf to make sure those wishes are honored. I think that's what estate litigation is really all about. That's really why we do the work that we do, and it's one of the main reasons why we're doing this seminar today. Without further ado, I'd like to call up Judge Jordy to start the event. And please don't make fun of him because he forgot his robes. Oh.
Good morning, everybody. I did not forget my robes, thanks to Ian Hull, who reminded me. But right now, I'm not Judge Jordy. I'm just going to introduce the facts of the case that we're going to hear today. So this is a pretty classic, in some sense, scenario. We have Sophia and her husband, Igor, and they have two children, Boris and Riva. Sophia's husband died predeceased, and there's a dispute now between the two children, Boris and Riva. Sophia is 79 years old. She's basically illiterate. She doesn't speak English very well. She's fluent in Russian and Yiddish. Boris is the youngest child, 47 years old, and he now lives with his mother, Sophia. Sophia's alive right now. Riva is the oldest child. She's got two children of her own, and she lives in Mississauga while her mom and Boris live in Thornhill. So Igor and Sophia did mirror wills back in 2005, leaving everything to each other absolutely, and then with a gift over to their two children equally. That's in 2005. Igor dies in 2009, and Boris moves in with Sophia into her home, takes her to doctor's appointments, generally runs errands for her, helps her. He also holds a power of attorney for property, and there is no issue in this hearing about the validity of the power of attorney. That power of attorney dates from 1997. So Sophia is driving in 2014. She's driving her car and she gets in an accident, and she's taken to Sunnybrook, and she suffers a right subdural hematoma. And she's in the hospital on March the 12th, and she's still in the hospital until May. But on March 20th, Riva comes to visit her mom, and the hospital won't let her in because Boris has used his power of attorney to ban her from the hospital. She's discharged in May of 2014, diagnosed as having early stage Alzheimer's disease. That's May. Then in June the 5th, Boris uses his power of attorney to transfer the house into his own name for natural love and affection. And it turns out that he has a postcard from Sophia written in Russian, dated 2014, saying, "I give you my house as a place to live." But the postcard is unsigned. That's June. Then in August of 2014, Sophia executes a new will, disinheriting Riva and giving it entirely to Boris. Sophia's lawyer is Heather Hogan, and she does a new will on August 26th. She has a couple of meetings with the lawyer, and they have known each other for some time. In fact, Boris also knows the lawyer. And it turns out, luckily, that Ms. Hogan has Russian literature background and can speak, or at least used to be able to speak Russian. And Boris is the one who contacts the lawyer. And there are a couple of meetings with the lawyer, and eventually the new will is signed. The dispute arises even though Sophia is alive, and there's an agreed statement of fact from which I've just read that the parties have agreed to. So defending, this is an application brought by Riva, and Riva is represented by Mr. Donovan, Mr. Hull, Ms. Whaley, and Mr. Sidlovsky. And Boris is represented by Mr. Lobel, Mr. Vanderzee, Ms. Stevens, and Ms. Burns. So I think that's the lineup. What we'll do now is I think we'll commence the hearing.